In the annals of legal discourse emerges the lamentable saga of a U.S. Navy veteran, whose unwavering response to the call of duty led him to enlist a mere 3 months subsequent to the tragic events of the 9/11 attack. Serving with distinction during Operation Enduring Freedom, this valiant individual, paradoxically, finds himself ensnared in a protracted web of duplicity orchestrated by the very government he once swore to defend. The gravity of this situation is underscored by the state of Florida's perplexing decision to decriminalize fraudulent activities in pursuit of revenue generation. Compounding this grievous state of affairs is the revelation that the attorney entrusted with safeguarding the veteran's legal rights, Attorney Renita Henry of Florida, consciously and egregiously omitted critical elements, including state tax, city tax, and mandatory retirement salary deductions. This act, devoid of legal rectitude, constitutes a stark misrepresentation of material facts and a blatant violation of the sacrosanct Florida statutes 61.30 and 839.13. The repercussions of such omissions are manifold, leading to the manipulation of referenced salary deductions, metamorphosing them into a distorted semblance of net income. In a legal realm where perpetrators of fraud traditionally face criminal prosecution, Attorney Renita Henry proffers a defense founded on temporal expediency. She asserts that her decision to omit pivotal salary deductions during the computation of the veteran's child support obligations was transitory, contending in accord among all involved parties that inclusion of the omitted deductions would be permitted during the final hearing. This proclamation introduces a disconcerting vagueness into statutory interpretation, casting doubt upon the legality or illegality of information omission during legal proceedings. The transgression is further exacerbated when General Magistrate Deborah Nabet Frankel of the 11th Judicial Circuit Court presides over a recommended order, possessing full cognizance of the fraudulent nature of the calculations, yet opting to label the verdict as temporary. Notably, at the conclusive hearing on April 29, 2019, at the 11th Judicial Circuit Court of Florida, Judge Scott Bernstein abdicates the mantle of impartiality. In executing a court order supporting the omission, he concurrently shirks the duty to report any detected impropriety to the appropriate authorities. Instead, he advises the veteran to seek redress through the avenue of appeal, a conspicuous indication of operating under the color of law. Legal imperatives mandate the reporting of constitutional rights violations to relevant authorities. However, an unfortunate collusion prevails among officers of the court, attorney generals, attorney bar associations, judicial qualification commissions, Department of Justice, and other governmental agencies entrusted with overseeing accountability in matters of judicial misconduct. This allegiance, regrettably, supersedes the duty to prosecute fraud on the court committed by officers of the court. A litany of complaints were documented as 7 to the Florida Bar, 5 to the Florida Judicial Qualification Commission, 2 to the Miami-Dade State Attorney Office, multiple to the Department of Justice, 2 petitions to the Southern District Court of Florida, 1 appeal to the First District Court of Appeal in Florida, and 2 petitions to the Third District Court of Appeal in Florida, elicits responses that paradoxically dismiss the gravity of the omissions, arguing that omitting information is not tantamount to fraud. Such assertions stand in stark contradiction to Attorney Renita Henry's own admission, elucidated in an email exchange on December 19, 2019, wherein she concedes that the omissions represent a deviation from established guidelines. Upon filing a petition against former attorney Renita Henry with the 11th Judicial Circuit Court, the veteran encounters the disheartening dismissal by Judge David C. Miller on August 6, 2022, followed by the spontaneous recusal mere minutes thereafter. An appeal of this court's decision meets a similar fate with dismissal by the Third District Court of Appeal on January 19, 2022. In the same year, attorney Emily Phillips, founder of the Miami Family Law Group, resolves to petition the 11th Judicial Circuit Court of Florida to enforce the court order executed by Judge Scott Bernstein. This audacious endeavor necessitates the submission of fraudulent evidence, facilitated by attorney Amelia Lynn Warchel of the Miami Family Law Group, through an Exhibit A containing child support calculations, conspicuously devoid of state tax, city tax, and mandatory retirement salary deductions. On May 4, 2023, before General Magistrate Gina Mendez-Locke, the veteran endeavors to underscore the potential for fraud on the court emanating from the misrepresented salary deductions. Regrettably, General Magistrate Gina Mendez-Locke, in an act of egregious disregard for constitutional rights, executes a recommended order endorsing the omissions and appends a writ of bodily attachment, a coercive instrument intended to enforce compliance, thereby transgressing the veteran's 14th Amendment rights. Subsequently, on May 11, 2023, Judge Samantha Ruiz Cohen of the 11th Judicial Circuit Court lends unwavering support to General Magistrate Gina Mendez-Locke's decision, executing a court order reinforcing the exclusion of state tax, city tax, and mandatory retirement salary deductions. In a futile plea for impartiality, the veteran requests that Judge Samantha Ruiz Cohen recuse herself, only to be met with repeated denials. Further exacerbating the situation, Judge Samantha Ruiz Cohen adamantly refuses to furnish copies of her court orders to the veteran, and the 11th Judicial Court rebuffs the execution of an order following the veteran's filing of 2 motions to vacate. The collective actions of these officers of the court and other governmental representatives have precipitated a state of affairs tantamount to fraud on the court, wherein material facts are either misrepresented or allowed to be misrepresented. Additionally, the veteran has been subjected to civil rights discrimination under the aegis of the Civil Rights Act of 1983. This federal statute imposes liability on any person acting under color of law who subjects or causes to be subjected any citizen to the deprivation of rights secured by the Constitution and laws of the United States. Corroborating this assertion is the statutory framework encapsulated in 18 U.S.C. 242, which criminalizes the willful deprivation of rights under the color of law. Furthermore, the 14th Amendment's Due Process Clause is unequivocal in its mandate that states shall not deprive any person of life, liberty, or property without due process of law. The disquieting incongruity between these transgressions and the ideals of a democratic America, where those authorized to protect and serve have chosen to abrogate laws for the purpose of defrauding and depriving citizens of liberty and property, underscores a disconcerting trend. The quest for redress through legal avenues is further stymied, as individuals are denied due process and the opportunity to have their voices heard. Moreover, the insidious introduction of new measures by the government, designed to legally defraud Americans by stifling their voices and mitigating accountability, begets profound questions regarding the navigability of a judicial system where judges and attorneys operate with unchecked authority, brazenly advancing corruption and constitutional ambiguity. This pervasive malfeasance has shaped a systemic corruption landscape within America's judiciary. The extent to which the government has extended itself to silence this veteran prompts a critical inquiry into how many other instances of discrimination are permitted to bolster financial support for state governments reliant on the collection of child support from non-custodial parents. This perverse incentive structure provides little inducement for officers of the courts to act on behalf of family development, especially concerning lower and middle-income households. In a landscape devoid of news media coverage, the enormity of this corruption by the government and the potential aversion of news agencies to become involved raises pressing concerns. In summation, it is evident that the judicial corruption in the state of Florida necessitates a comprehensive intervention akin to the Grey Lord operation undertaken in the state of Illinois in the 1980s. Astonishingly, officers of the court and the state of Florida, ostensibly charged with upholding justice, are permitted to retaliate against this veteran for his steadfast refusal to relinquish rights he fought to preserve. Following a car collision and subsequent unemployment, the veteran suffered the confiscation of $72,000 from his insurance settlement, a $7,500 tax refund, and endured 3 suspensions of his driving license in 2023. Culminating in a permanent suspension of both his driver's license and car registration on spurious grounds of a fraudulent $1,100 child support arrearage. Of note, these punitive measures were accentuated by symbolic license reinstatements and subsequent suspensions, seemingly indicative of the state of Florida capriciously toying with and retaliating against the veteran. The permanent suspension, notably occurring shortly after the veteran filed complaints against attorney Renita Henry, attorney Emily Phillips, and attorney Amelia Lynn Worchel with the Florida Bar and Delaware Bar, raises pertinent questions about the retaliatory nature of these actions. It is incumbent upon us to recognize that in cases of fraud on the court, the entire legal proceeding is rendered void, nullifying any judgment or ruling issued by the court.